Good afternoon, everyone. Welcome to our 2024 case law update here for LOMAD. My name is James Cousins.
And I'm Brandon Shannon.
Really Herculean task, which is reviewing, gathering, and assessing all the cases that were dropped by the Appellate Division during the course of 2024 to see and assess what is the state of the workers' compensation law after we've had a year of litigation and decisions.
One thing I'll note is that this is our 5th year doing this together.
Is it really?
I still don't feel like I know anything about what the third department is doing any given year. Where they're coming from.
Well, I can tell you that this year was really interesting. I gave this presentation at the NYS conference earlier in the year, and the conclusion I came to for that body was that the third department is still feeling its oats in the post-Tahar and Arias moments. There's some reactionary thoughts there. We're going to talk about a few decisions today that were flat wrong, that seem to be sort of self-satisfied in the way they were written, that are trying to tell us our business as though they figured out something that we don't already know. And on two cases where they did something and they knew that it was so questionable that they themselves granted cert and appeal to the Court of Appeals, which is incredibly rare. So, you know, there's a lot going on. It's really hard to figure them out on a day-to-day basis, though. You're right. All right. So without further ado, let's move on to the next slide. I do want to take a moment before we get into the substance here and dedicate this presentation to my father. Many of you know my father passed away late in the fall of 2024. He's the reason that I'm here, obviously, literally, but also figuratively. Our family ran a business for quite a long time, and he made the decision when I was younger that he thought the American dream was appropriate for me. He wanted me to be a doctor or a lawyer, didn't want me to have to run a business like he did, didn't want to have me stuck into the family business. And so he encouraged me to go to law school and always told me that he enjoyed it and that I'd better save other businesses money because I couldn't save his business any money. It was located in Pennsylvania. So I spend a lot of time and attention representing our clients because I get the satisfaction of knowing that I can help other businesses like I couldn't really help out my father directly. So I just wanted to mention here. All right, let's talk about a little data. Statistics. This is sort of as you'd expect. When I first started practicing, the affirmance rate was higher, but it's sort of settled in around 75% of all decisions that go up on appeal are affirmed. Reversal rate was 21. What was odd here is we had 4%. We had a couple dismissals.
More than usual, I felt like.
It was more than usual, and there were a couple times where the court said some really strange things, like they didn't find anyone aggrieved, and of course they said that last year on an apportionment decision, and then realized that they totally screwed it up.
Yeah,
and had to fix it. So reversals was 21, and I put an asterisk there because that could be a reversal or a reversal with a remittal. And a lot of times we know that if there's a remittal, the board is going to take steps to correct whatever error was determined by the court in its analysis, and then reach the same conclusion if they can by correcting the error. And just as a joke, Jeff Schotter appeals so many cases. Like, how does he find the time to even practice law by going to the hearings? And where the hell does the money come from? Records on appeal are expensive. So 20% of all the decisions that were issued in 2024 were appeals taken by Jeff Schotter.
That's impressive.
It's annoying. And we'll talk about some of the annoying ones later. All right, let's move on. I know I'm talking a lot. We'll get to Brendan here shortly. I've decided to take the first case. Temperio v. Bronx Lebanon Hospital. If you watched last year, we talked about this case, or 2 years ago, we talked about this case. The third department let this guy have his lawsuit. That's what this is all about. The facts of this case are pretty simple, although they're tragic. A former employee of a hospital walks back into the hospital with a firearm and shoots a lot of people, among them Dr. Temperio. Dr. Temperio is very seriously injured, but ultimately he heals and he's able to return to work. A workers' compensation claim was filed on his behalf by his employer, was established, and throughout the course of really extensive litigation, lots of machinations, it turns out the claimant doesn't want a comp claim, but the employer does, and we all know why. because the employer doesn't want to be sued in tort. I mean, this is a terrible tragedy.
Right.
Even though he's alive, he was shot in a hospital on a mass shooting. The idea is he wants to sue the hospital. He knows he can get a decent reward out of the hospital if he's able to sue them, but he also knows that comp is not going to compensate him in any way, shape, or form near that. The case gets to the third department. It's established by the board. Got it right. Good on you, board. Right? It's a work-related injury. It was an assault at work that was not purely personal. That's the standard, right?
Right.
The third department comes up with this nexus language. You'll see it in here. You don't need to read it right away, but they basically said, oh, we need to have a nexus to employment. Otherwise, the absence of any link to employment takes us outside the scope and course. Ergo, the presumptions are rebutted. So they basically said the presumption of Section 21 that an accident that happens at work, ergo arises from it, can be rebutted if you have a great big black hole of evidence. and the point that ends up being made, it goes to the Court of Appeals. Obviously, the Court of Appeals has to take this up. They rewrote the way that the presumptions worked. And in fact, as defense counsel, I would have been really happy for the underlying third department ruling to stand, because it would have been a way for us to knock a lot of cases out of comp. Because they basically said, unless you can establish some nexus to work other than the happening at work,
right,
it's not work related. I mean, I know that the case was limited to this assault claim, but the problem is that the language is so broadly written.
Right.
They completely misunderstood the law. That's the part that kills me. Later, we'll see them taking steps to prove to us how smart they are. But here, they completely misunderstood the law. The Court of Appeals got a hold of this, issued a decision in May. It could be a textbook. It could be a section from the textbook about how the presumptions work, telling the third department that they got it really, really massively wrong, and they reversed. And I watched the oral arguments when this went up to oral argument, and I was heartened by the fact that the judges of the Court of Appeals right away understood what was actually going on in this case. I mean, they flat out asked the appellant, what's the reason that we're here? And the appellant sort of shirks, and the judge replies, well, we all understand that you want to file a suit in tort, but exclusivity isn't a part of this case. I mean, this case is actually about exclusivity.
It is.
The whole underlying case is about exclusivity.
Right.
The hospital wants to have a comp claim so that they can't be sued in tort. The employee wants to have no comp claim so that they can essentially elect a remedy. They were trying to use a really unique reading of the law to elect a remedy. It doesn't pass the smell test.
No. Yeah.
I was just shocked that the Appellate Division came up with it. So,
well, the 21 presumptions are one of the most commonly referred to citations in all of comp. So,
but also apparently really easily subject to misuse.
Yeah, true.
I mean, the Appellate Division loves telling us, oh, well, the presumptions aren't a substitute for evidence, right?
Right.
And in this case, they just totally whiffed.
So moving on to Cross v. New York State Department of Corrections. This is a fairly interesting case, and it's one of the dismissals that we talked about. We said that there are a few more this year than usual. And this involved a situation where the carrier, I'm not sure if it was a carrier or a self-insured employer, but the carrier, I believe, had arranged for any sort of diagnostics to take place within their network, which is obviously something that anyone on this call is very familiar with. We deal with it all the time. And just as an aside, note that if there's ever a CAP1B related to that CAP1B should be found in favor of the carrier, and it shouldn't be like at network rates or anything like that.
Right.
Now here, the claimant underwent, a pre-approved diagnostic test, and it was out of network. So it was, ultimately the objection to that it was found for the carrier, and the claimant tried to appeal that issue. However, it was found that basically the claimant does not have standing to appeal the CAP1B that was found in the carrier with respect to a diagnostic test performed out of network, because the claimant was not responsible for the bill. So that's a very under Section 13 of the workers' comp law, that's a very, very common finding at a hearing when except for in unique circumstances.
Yeah.
When a CMB is found as a carrier, it's usually noted that the claimant is not responsible. I actually think this is a pretty good decision that
If I'm the ARD at the board,
Mhm.
I'm going to bring this down to the panel level,
right.
and I'm going to start denying C1 appeals that might be filed by claimants where there's a 13F finding of claimant not responsible, and I'm going to deny them on grounds that like we've reviewed, like we have 123 jurisdiction, so we understand that we have to or we can.
That'd be great.
And I would just say, nah, you don't have standing to appeal this. Oh, by the way, you're not aggrieved, so you can't appeal this. Oh, by the way, our other decisions say that the doctor can't appeal it either. It's not. It seems unfair to the providers, but you know what? This is the way that we're going to train them.
Right.
It's it's like paper training your dog, right?
Yeah.
Like they're gonna have to learn, and this is gonna be the way. There's gonna be no appeals.
Well, if you want the benefit of treating comp patients, which is obviously very financially lucrative, you need to follow the rules. But the one thing I'll just note real quickly that a footnote mentioned that sort of how the claimant tried to establish that she had standing was that it could affect her future treatment, which is kind of interesting when you consider that it was a diagnostic test. It's not like, like her doctor.
Well, it's also
not getting paid.
I think it's sort of the public policy that the board takes about providers is they do want to be provider friendly. Mm-hmm. They want these people to stay in the system. But when it comes to the third department, they're just like, that's just mere speculation. That's just trash. They dispose of it in a footnote. You know me, I love footnotes. They usually tell us a lot, and they really case it does.
So I'm also going to talk about the next one, which is Morgan v. Kinray. And just getting into that one, I think we can actually talk about this one pretty quickly because at this point, you're probably tired of hearing us talk about the Appellate decision from a couple years ago. We talk about it all the time, both every year in this presentation since it came down, as well as in our video series that we release each month, because it's something that we use pretty frequently to successfully litigate occupational disease or repetitive use claims. It just as a reminder, that's the decision that basically held that any opinion on causal relationship in such a case like an occupational disease or repetitive use needs to be very specific as far as what caused the alleged injury, and it has to go into detail as far as the amount of time the claimant spent performing each individual job duty and body movement, and then explain how that could have caused the injuries being claimed. You also want to discuss things like weights and whatnot that are being maneuvered or pushed or pulled or what. This case is another one of those cases that just continues to strengthen that decision and the string site that we would use to support, a disallowance in these type of claims, where the claimant's medical evidence, while it did sort of, offer opinions linking the, extensive complaints to the job duties that were described, it didn't really go into any detail as far as the frequency with which these allegedly repetitive body movements were performed. So obviously you can't have repetitive use injury if your medical evidence doesn't really talk about the repetitiveness of that motion. And in this case, the claim was disallowed under that Appellate decision, where there just wasn't sufficient evidence on the claimant's part. And the one thing that's a little bit interesting here is that this is the rare instance where the carrier got an IME. Now, frequently we would not recommend an IME in a Appellate case. I have had ones where I've recommended them where I thought it was borderline Appellate compliant. So I could see why sometimes a carrier will get an IME in these cases. You might think their evidence is borderline. What if I actually produce the job description or something like that to my IME doctor and see if they find it? I've had something like that. But yeah, this is a situation where they did get an IME, but Appellate was still found to support the disallowance.
I would really like to, if anyone out there knows about this case, I'd really like to see the IME cover letter and the IME. I'd like to see how they manage that. Let's move on to the next one. We're going to talk about Song v. City of New York. I want to talk about this claim because this claim is annoying, and you probably saw these claims, and many of you may, in fact, have played a role in them. I've seen them be accepted without litigation. Song v. City of New York is basically a burnout claim. It's a COVID case. The claimant's sent to work from home. She's burned out from doing her work. She's working in a weird posture. She starts to have weird physical symptoms that then lead to psychiatric symptoms. She's just basically claiming that working from home, she's working more, she's doing more people's jobs, she's burned out. This case is disallowed. Thank the maker, right? This is a case where we go back to fundamentals, right? The decision reminds us that an OD arises from a distinctive feature of employment, but an accidental injury, like a repetitive stress type claim, which is an accident, might arise from an unusual environmental condition or events assignments to something extraordinary, right? That's repetitive stress. It's not doing your normal job. And in this case, it boils down to being an ergonomics claim. And the case law is pretty clear. You'll see our footnote here, Matter of Transportation Departments 2019. That's a board panel ruling. It's part of a long string of cases. Ergonomic ODs aren't a thing. If somebody claims a work-related occupational disease that stems essentially from something that we would call ergonomics, that's not supposed to be a claim. It's distinctively not an OD. It's environmental. And then if it's environmental, then it would constitute an accident. And for it to qualify for compensation at that point, the case law says it has to be something extraordinary. Right. And the position of your mouse is not extraordinary. The position of your keyboard is not extraordinary. Yeah, but you know what I mean? And I know I've seen them cases just like this be accepted. They're garbage. They're not compensable. But this is the kind of stuff that we hope through the process of this educational presentation, you learn. And you might keep this one in your mind. If you see something like, wow, that seems like an ergonomics case, poke your counsel.
Right, exactly.
Right.
So moving on to, I'm going to just call it ROCAM, but it's kind of hard to pronounce, which is another COVID claim, but it's a little different from the one that James just discussed, in that this was a COVID death claim. And we're going to kind of contrast this with another decision that came down this year, or this past year, in Flores v. Wellwood Cemetery Association. This is a claim where the decedent really didn't do a very good, or excuse me, the claimant did not do a good job of establishing this claim.
No.
So basically what happened here was, obviously the claimant was not all that intimately aware of how the claimant could have been exposed to COVID. Now, as a reminder, sort of the law of the land as far as COVID claims now is that you either have to establish that you were specifically exposed to COVID or that there was prevalence of COVID in your workplace. Now, as you can imagine, the first one may be difficult, but is the more straightforward way of getting a COVID claim established. The other one's very nebulous, and it's something that on our side of the bar that we've taken issue with, especially considering the circumstances with which it's become the law, which is really just the board developed it in board panel decisional law, and the third department agreed with it. Anyways, in this claim, the claimant produced medical evidence that was extremely vague. The doctor, I'm going to read a quote from it because I think it's illustrative, demonstrated no familiarity with the particular characteristics of the decedent's work environment or the prevalence of infection therein, and mistakenly believed that no one else in the decedent's household had COVID during the same time period. Now, what's interesting here is that basically the way that it was sort of presented that it should be established for COVID was that there was sort of a hearsay statement from the claimant's, or excuse me, the decedent's physician that the claimant got COVID at work.
Yeah, the decedent, while he was alive, went to the hospital and said, I got this from work.
Yeah,
and they copied it down and put it in the medical record.
Right,
Yeah.
So that was it. That's all they had on it. There was no testimony was taken about how much, that proved that there was all this
prevalence. Yeah, prevalence or coworkers.
Right, or that he was exposed to someone. And then there was also evidence that was contrary to the claimant's medical that someone in his household had COVID around the same time. Yeah. So in that instance, the claim was disallowed and the court affirmed. Now we put a comparison in the Flores case because that's an interesting case involving a gravedigger during the COVID pandemic who also passed away, I believe, due to COVID. And that case was based on hearsay in the sense that the claimant or the decedent at some point had stated that his coworker buddy got him COVID.
That was it. The decedent told his spouse that Billy coworker had COVID, and that was enough to establish an actual exposure as opposed to a pseudo, whatever they were trying to do in rock camp.
Right. And like why those differ, I mean, your guess is as good as mine, right?
Yeah.
So moving on to McNulty v. Craco. This is a 114A claim in which basically the claimant had testified at one point that he had done no work or earned any income apart from his comp benefits. However, he had just pled guilty and been found guilty, or well, he pled guilty.
He pled guilty
to charges of selling weapons illegally.
Selling weapons. He wasn't bartering them, he was selling them.
Right.
Okay.
So, I mean, we've had some interesting cases involving claimants who are, like I had one claimant who was selling homemade body butter. It's a little different from selling illegal firearms.
Right.
Well,
one's a felony.
Right. And in this instance, the board actually held it in abeyance because they couldn't produce the claimant to the hearing that was supposed to address the issue of 114A.
Which is kind of silly. It's the 21st century. Like,
yeah.
You telling me that he's not making appearances at other hearings for his other criminal cases? Yeah.
But I think you would agree that in this case, it sounds like there was a textbook 114A violation since the claimant testified under oath that he was not being paid for any other work, and that's clearly false. But I guess technically they did the right thing here in holding in abeyance, but why the claimant was not available to appear at that hearing is kind of anyone's guess at this point. I'm assuming that if there was some work done on the part of the claimant's lawyer, that they could have gotten the claimant to appear for that hearing.
But why bother doing work when he's just going to? And what's really problematic about this is that the AD says some really, I think, makes some inappropriate comments, and it's dicta, and they're basically saying, well, we're not sure whether the claimant's guilty plea, quote, determined or even contemplated a violation of WCL section 114A. It was weird. It's like the court went out of its way to suggest that somehow this might not be essentially a preclusive, like, res judicata kind of fraud, especially since like the elements of selling firearms illegally involves selling.
Yeah, it is weird.
Right? Like the claimant's almost has stopped based on his guilty plea from saying that he didn't make any money on it or that he wasn't doing it, right?
Right.
He pled guilty to doing it. All we need to prove is that he lied about it.
Right. Would sound like the evidence already is there.
Yeah. We want to take a few minutes and do a comparison from two other fraud cases, the Geiselman case and the Lane case. Both of these cases have really substantial footage in them, the volume, the amount of footage that's going into them. One finds 114A with a lifetime disqualification. The other one says no violation. And the real difference between the two cases that I want to illustrate for you guys out there in terms of how to handle these claims. You're going to note in Geiselman, where we have a 114A finding, the record is developed carefully. So they know how much the lawnmower that he's lifting weighs. They got evidence in it. They know how much the screen door weighed. They got evidence in it, right? They took the testimony of the treating physician after insisting that they watch the video. And the physician says, I really can't tell you what I'm seeing here because I don't understand it, right? It's not even like it's smoking gun physician testimony. It's just the doctor was clearly flummoxed by it and can't really say that he sticks by his guns, and he can't really say that he's throwing his guy into the bus, right? That's a lifetime ban fraud finding. Compared to Linane, we have 7 months of footage, but a bunch of the video is just the claimant driving or sitting. When they do have the claimant moving stuff, they never produced evidence of what the bags weighed. It was bags of soil. Soil is heavy.
Right.
You could have gone to the website of the company that makes it, or of Lowe's or Home Depot, wherever he got it, and entered into evidence how much the bags weighed and how much he was moving them. And they never sent the footage to the doctors. So they never got testimony from a physician saying that the footage was inconsistent. That's
not even to the IME.
Not even to the IME. They got testimony, but they never saw the footage. You cannot win a malingering fraud without a medical opinion.
No, you have to send it to your IME.
You have to send it to your IME. it's law 101. The judge cannot create a medical opinion, and you would be asking a judge to create a medical opinion saying that I saw the video and I think the video is inconsistent with the IME. That's a medical conclusion.
Mm-hmm.
Let the doctor who did the IME look at the video and say, yes, that is medically inconsistent. And it's firsthand. The IME saw the claimant. The IME did the examination. Therefore, now the IME is now seeing the video, which self-descriptive. It's basically firsthand. Right. So now we've got great evidence. So there are sometimes plays, like snap plays, right? This is like the basic bootleg, right?
Yeah.
Don't try and reinvent the wheel.
Right.
Just follow the playbook. It's really simple. And in this case, the playbook is described and is created from really clear, settled facts and really clear, settled elements of evidence. So don't make that mistake.
One thing I just want to mention with this case too that I find kind of interesting, and it's not the the basis of the decision like that.
Yeah.
But it sounded like, if I recall the facts of this case correctly, this was a guy who was basically helping his wife at craft fairs, right?
Yeah.
Does that sound right? And I think, if I remember correctly, part of what was discussed there, or at least something that does get discussed in these type of cases sometimes, is like, well, like, is that really work activity? And I have a case like this that's currently ongoing where it's, the allegation is that, he was helping his girlfriend with something he didn't personally expect to benefit from it.
Right.
I think that's something we should try and push in the future, because it's like, it's still work activity, right? I don't know. That's just like an aside.
There are decisions out there that say that it's not necessary for you to, in your personal benefit.
Exactly.
It's if you worked anywhere or done any activity or earned any income that might be considered work.
And I would argue if your wife financially benefits, like presumably you financially benefit.
Right.
Right.
Yeah.
So,
I would think so.
All right. So that was just an aside. But moving on to, I'm not even going to try and pronounce the name of this case. I'm going to call it the Pelham Bay Donuts case.
Wait, we're talking about Dent. Great.
Oh, I skipped a case.
Yeah, you skipped a case.
Going back, not talking about that case, talking about Dent, which I'm mad that I almost skipped this one because this is my favorite issue in comp, which is gray area cases. And if you're not familiar with the concept, the idea of a gray area case is basically like there's a certain understanding and a general rule that an accident that occurs while commuting is not compensable unless. Now, the unless is the gray area that we're talking about in these cases.
Otherwise, we wouldn't have a job.
Right, exactly. And the idea of a gray area case is you're considering whether, like they were kind of close enough to work for it to be potentially considered, in the scope and course of work, and also whether they were exposed to any sort of hazard that would be really only unique to an employee of the place that the claimant worked at. Now, in this case, this is like a very bold claim by the claimant. The claimant worked for Amazon in the New York City area, and the claimant was injured while getting onto the bus to go to work. So not getting off at her work site or anything like that. Getting onto the bus to go to work.
No, she was leaving. This is the leaving case. So this is the.
Am I mixing this up?
Yeah, you're leaving this. So she's done with work and she gets out of work with like 500 other Amazon employees, but there's one bus.
Yeah.
And she gets trampled trying to get on the bus because everyone wants to get on the first bus.
Yeah.
Because they don't want to wait for the second one.
So, so I mixed it up a little bit there, but she gets trampled getting onto the bus, and the bus that she's getting onto, it's not, the bus stop's not located at Amazon.
Yeah.
It's not arranged by Amazon. There's no agreement between the city and Amazon to include, MTA transportation to Amazon. And for that reason, it was found that there was no special hazard, because if you look at it, if you're thinking about what a special hazard is in a gray area case, you're considering whether, the claimant the hazard would be something there. It's like only these Amazon employees are exposed to this, but this is just a public bus, not on Amazon's premises, that the claimant got injured on or basically outside of.
Yeah.
So in this case, it was disallowed and affirmed at the Court of Appeals level because, again, the claimant was not exposed to any special hazard, and therefore it was not in that gray area that would provide an exception for a claimant who's commuting to work and getting injured in that commute.
And Jeff Schotter filed this appeal too. Let's move on to Lachage. I'm going to try it. Lachage. I'm going to talk about jurisdiction real quick. Jurisdictional cases don't come up very often. That's why I want to talk about it, because it seems like it's fun and it's interesting. And it brings us all back to all of us lawyers. It brings us back to law school, the substantial contacts tests. And it highlights a change in in the world we live in that comes from the internet. In this case, we have a truck driver who's a New York resident, but there's no other connection to New York. The accident occurs in Pennsylvania. He's transporting a load of goods from Ohio to Massachusetts. His employer is based solely out of Illinois. They do no activity beyond New York. And by the way, the claimant was hired online. And where the claimant is hired is one of the list of substantial contacts that is listed in FedPro and State Pro when you're talking about whether subject matter jurisdiction can apply and whether the state has any interest in deciding the claim and applying its law to the case. This is the point I wanted to make. We're living in a world now where you can have an employer who never actually sits in the same room as their employee.
Right.
That is a thing now. They will have been hired online, right? There are plenty of businesses that have business activity that is nearby or passes through or has limited impact with New York. But it's going to happen more and more often in the world we live
in. Yeah.
And I also wanted to point this out too, is that this came down on October 10, 2024. We're state of the art here at LOMAD, and we're at the tip of the spear. I had a hearing on October 11th on this exact issue, and you can bet I walked in and said, the third department just issued a ruling directly on point. Can we please leave? And unfortunately, the UEF was not going to behave, so now I've got to go through it. But this is why you read this stuff when it comes out.
Definitely. All right, so now I'm going to talk about the Pelham Bay Donuts case, which I'm going to try and move through pretty quickly because we want to get through some of this labor market attachment cases to get to some really interesting ones down the road before we're done here today. The gist of this case is that the claimant was classified PPD and also found unattached to the labor market. Now, the general idea is that, the claimant can then reattach, obviously, under the statute. But the way it's sort of operated since the amendments in 2017 is that if the claimant is attached at the time of classification, they don't have to continually demonstrate attachment to the labor market. Now,
they're excused indefinitely. I call it vaccinated.
Exactly.
They're never going to get a labor market challenge again.
Right.
They're otherwise entitled to benefits.
Yeah. There are some little exceptions to that, and we're very aware of those, and there are ways to litigate, voluntary removal and whatnot after the fact, but they don't have to keep submitting job search efforts or anything like that. Now, in this case, it kind of opened the door to like two different types of claimants, if you will, in the sense that in this case, the claimant, having not been attached, it was basically determined that the claimant has to continually demonstrate attachment after the fact. Like, he doesn't get that vaccination
by subsequently demonstrating attachment. Yeah, it has to happen. That the amendment to the statute is extremely time specific. It only looks at the claimant's entitlement to benefits. The time classification is made.
Exactly.
And it's bimodal. It's yes or no. And you cannot retroactively vaccinate yourself by reattaching to the labor market.
Right. So he reattached, and then it's like, it would still be possible to litigate the issue of labor market attachment down the line, which normally we wouldn't have that protection.
The claimant in Pelham Bay is going to be subject to labor market challenges for the entirety of his non-scheduled permanent partial disability.
Exactly.
They can continue to raise it, and the board can't stop it, and the claimant's going to have to continue showing proofs.
And that's a great decision for our side of our.
Yeah. All right, let's talk about Vucodic. This is we're just going to say that we brought up Vucodic because this is a concept that the plaintiff's bar is continually challenging. They've challenged it almost every year for the last 3, if not 4 years. They really, 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 really want non-vocational factors to play some role, or vocational factors to play some role in temporary disabilities. So we got LWEC back in 2007, right, with those reforms. The plaintiff's bar likes that. They want vocational factors to apply in any way, shape, or form they can during periods of temporary disability. They have lost every previous attempt. This one was a new theory. is that not that vocational factors can be considered in connection with the physical disability to create a labor market attachment, basically waiver. The claimant cannot be challenged on labor market because their physical disability in connection with their vocational factors that are probably aggravating render them essentially unfit to return to any employment. And during periods of temporary disability, they wanted to sort of cleanse their client of any possibility that they could be challenged on LMA.
Yeah, this decision was very vague too. I went back to it before today's presentation to kind of remind myself of what those vocational factors were.
Yeah,
they're not mentioned.
This is Gray and Gray, by the way. This is the same law firm that keeps doing it on the same. They keep bringing the same issue and the same theory to a different fact.
One thing I'll note too, James, because I looked this case up today, I noticed that leave to appeal to the Court of Appeals was denied.
Of course.
So
yeah, it's
this approach by that law firm could be dead at this point.
Hopefully.
Yeah.
But they'll keep doing it. All right, you got LaPan?
Yeah, okay, so LaPan, another labor market attachment claim. In this case, basically it was determined an issue that we deal with frequently with labor market attachment claims is that claimants counsel will throw hundreds of pages into e-case to try and basically just show like an extensive quantity of labor market attachment efforts. And what will sometimes happen, sometimes, certain defense firms will look at that and say that's sufficient. Frequently, the judge will look at it and be like, how could I possibly find
600 pages? There's 600 pages, people.
Yeah, how could I possibly find that the claimant's not attached with 600 pages? And we've always taken the position here, which is that it's quality over quantity. Yeah. Labor market attachment, what you're considering a labor market attachment is diligent and persistent search for work within a claimant's work restrictions, or there's other ways. You could actively participate in vocational rehab. Now, in this case, there were over 600 pages of job proofs. There was evidence that the claimant was in vocational rehab, and there was also evidence that the claimant was taking English as second language courses. However, so in this instance, basically the court reversed and remitted and reversed, basically indicating that they thought the claimant was attached due to all these job search efforts. But
the third department was dazzled by his BS.
Exactly.
There was 600 pages of it. Oh, he must be attached.
Yeah, but what's interesting is that if you read the dissent here, which James notes in the Nota Bene, is kind of rare in comp. Actually, there was one in the 2025 case that we've already had with a dissent. But in this instance, the judge who made a dissent noted that, if you really look at these job search efforts, they're not in English. So there was never any translation to be able to verify that the claimant was actually searching for work within his restrictions or actually searching for work. Because sometimes people just fill out these forms. Yeah. And while the claimant was, there was some evidence that the claimant participated in vocational rehab, he stopped participating in it once they told him he needed to take ESL courses. So he wasn't actually actively participating.
That's why I speak English.
Exactly.
Whenever make it easier for you to get a job.
Yeah, and so he wasn't actively participating, and someone might argue, okay, well, but he's taking ESL courses. But the thing is that education is only a form of market attachment if you're full-time, which is over 12 credit hours, at an accredited institution, so like a college. Yeah. Not as an ESL. Now, an ESL course could be persuasive evidence of labor market attachment if you continue to actively participate in vocational rehab, but he didn't in this case. So this was remitted. Presumably the board will come back in favor of the claimant in this case, but it just kind of illustrates why you want to attack labor market proofs, regardless of how many are in there, because we've seen it time and time again. I've won on this issue before, where you just kind of go through it in the testimony, and then eventually the judge is like, "Oh yeah, none of these are actually legitimately within the claimant's restrictions or whatever."
There's a lot of stuff here, but it's all garbage.
Exactly.
So we gotta speed it up. So I'm gonna take over here on DePipio real quick. We got another case. This is on litigation and appellate practice. What's funny about this case, the reason we chose this is this would ordinarily be a burden of proof case, and this would be classic expressions of probability, possibility. Defense counsel in this case does a great job proving and picking apart claimants' proofs. The doctors concede that they can't say for sure, that there's speculation, that their opinions aren't particularly firm, they can't say for sure, et cetera, right? So the proofs fail. What makes this funny and interesting is that the claimant's appeal basically argues, I've been dealing with this condition forever and I've had a bunch of surgeries, so I'm an expert and I believe that this is causally related and you should consider that in addition to my doctor's proofs. Like you should use that as like a plus.
What was that case in law school where you talk about who an expert is?
That's
I
basically.
can't think of the name, but it's a famous one.
Yeah, and that's essentially what this is. This is the second time, by the way, this case has appeared on the appellate practice guide. The claimant, it seems like, is pro se and taking appeals on their own and making some mistakes. They perfected this one properly. But the ADs made a really funny comment in their decision. They said, quote, there's little question that the claimant has an opinion as to the cause of the amputation of his right leg, but he simply fails to qualify as a medical expert. And that's just a reminder of, always remember where it's coming from. Think about the fraud case we discussed earlier.
Yeah, it's an entertaining decision. You want to skip before?
Yeah, let's skip that. We only have like 20 minutes left.
So we'll go to Hickey just because that one's interesting and quick.
Yeah.
So next slide, please.
Yeah.
And all right, so Hickey involves an issue that shouldn't come up but does come up, which is basically a conversation. We call it ex parte conversation, a conversation that's not in front of the other parties of interest with a doctor. Now, as attorneys, we're beholden to Section 13A6 of the Workers' Comp law.
Well, technically the claimant is too.
Oh,
that's what
we're going to get to that.
Yeah.
We're going to get to that. But I mean, I should just say in general, we're beholden to Section 13A6, which is, if you're trying to persuade a doctor without copying other parties on that correspondence, then that can be considered not just inappropriate, but a misdemeanor. And at the very least, I don't think you'll ever see any criminal litigation off of that. The doctor's opinion should be precluded. That can be cured if you just simply copy the other party. There's also issues with if any of the correspondence is unduly suggestive, like leading questions. Here, the claimant, who was pro se, wrote, so this was a death claim, wrote to the decedent's physician, via an ex parte email that was not copied to the carrier or carrier's counsel, asking for a causal relationship opinion, and sort of going into like actual substantive issues with this claim and trying to kind of persuade the doctor into finding causal relationship. Now, and
provided a whole bunch of information that was not in evidence.
Right.
Like facts not in evidence.
And somehow, despite all of this, it was not found to be improper. So now, if James or I did something like this, or even most, I would argue, a claimant's attorney, it would be caught and it would be, precluded under 13A6. So what's kind of curious about this case is are they taking the position that pro se claimants aren't beholden to the same requirements? Seems to be the case.
This is result-driven decisions.
Right.
This is a result-driven decision. If you look at the Powers case from 2 years ago, essentially the same activity undertaken by a claimant's attorney was they burned the guy at the stake in the decision. They were like, this is entirely inappropriate. The claimant lost a valuable claim because of the activity of our attorney, right? They weren't happy to excoriate the attorney. But in this case, because it's a pro se claimant doing essentially the same stuff, they reach a different, this is the problem with the board. And this is the problem with the Appellate Division. If the Appellate Division is gonna occasionally get like a little bit punchy, this is the case where they needed to get punchy.
Yeah.
This is the case where some clerk at the Appellate Division had to go, wait a second, I swear to God, we've seen a case just like this a few years ago. How did that one come up?
Right.
And look at them and go, how could we possibly not find this a violation of 13A6 when we affirmed all this other activity in this other case as being a violation of 13A6?
And if you sort of consider the public policy behind it, I mean, if you want to give sort of leeway to a pro se claimant, it could encourage claimants to represent themselves pro se, which I don't think the
board wants to do. No.
So I don't understand why you would give them sort of special circumstances there.
Let's move on to Garrow. This is one of our very important decisions of the year. If you remember, we had the Blue case come down in 2022. 2022 was a funky year, right? You keep saying this other case in 2022. Well, in 2022, the Blue case came down, and this is the case that essentially defeats what we were using as a lot of the restrictions on maximum schedule loss of use awards that were generated from special considerations. The Blue case said, you get the special consideration award, up to the maximum, but if you have separate and distinct pathology, you're not precluded from adding points to it in relation to the additional pathology, provided that it's not solely incorporated into the special consideration. The board, much to their credit, and the way we wanted it read, they read that very narrowly because it applied only to condyle patella of the knee. And the board basically was rejecting left and right claims to expand the application of Blue to other special considerations. The problem is the plaintiff's bar actually had a good point because the wording of the special consideration, I think it's 6 for condyle patella, is very, very similar to the wording of dozens of other special considerations in the guidelines, and all of the assessment of schedule loss of use that are provided in each section for each body part are largely identical about how you go about assessing it. So unfortunately, now Garrow v. Lowe's Home Center says the analysis that was provided in Blue applies anywhere and everywhere where you run into a special consideration that speaks to a very specific physical condition, and the claimant has pathology both for meeting that special consideration and separate and apart from it. So they could be getting all those cases where we got significant knee range of motion losses limited to 10% because of chondromalacia. If there's evidence of the meniscal tear, they could get range of motion on top of it, which is pretty terrible. It seems like all of the concessions that we've obtained on the employers and carriers side in the last 10 or 15 years from the various amendments are being chipped away. And there's an obvious and very clear effort. I don't know if these things were contemplated at the time negotiations were made, but it's very clear we've lost almost everything.
Yeah.
The 07 amendments that limited that provided time duration caps on it were given in exchange for the average weekly wage increases, the max rate increases. That bargain could never be made. If you went back in hindsight and showed what happened, they would never make that bargain because it's increased costs exponentially. We're now at a place where schedules are so valuable that people that have really significant non-scheduled permanency awards are trying to skip them so that they can collect their schedules. I mean, you could have your back broken and your case is worth less than somebody who sprains their shoulder.
Yeah.
I mean, this is ridiculous.
I'm curious, do you think that if there's ever an analysis of the data on that there could be another reform?
There'll never be data.
There won't be, yeah.
No, it'll never be published.
So what happened in Germano?
Yeah, so in Germano, this is the second part of destroying Genduso on schedules. If you recall, the Genduso decision said that if a claimant has a schedule loss of use for a limb, and the limbs under the statute are arms and legs, right? Hands and feet. So you could take credit for it. And the case that was in Genduso was essentially shoulder elbow. A shoulder schedule, you get points from the guidelines for permanency that are specific to shoulder conditions and range of motion for that joint. You also get separately and in the same way get points for the elbow. But the Genduso decision said, listen, if you had a prior 20% elbow and you now have 20% shoulder, carrier number 2 on case number 2 is going to take credit for that prior 20%, regardless of any analysis of the medical or the separateness of the loss of function. This is just a pure reading of the statute. It gets to the Court of Appeals who says this doesn't make sense. Now the Court of Appeals gives us 2 decisions in Johnson and Leone that have to be read like 17 times to figure out what the hell they actually mean. But they basically come down to the doctor having to say that, or to demonstrate, and this is the exact language from Johnson, that the later schedule is entirely separate and distinct.
Magic words.
Those are the magic words. However, now in Germano and in Webster, we learned that entirely separate and distinct is not going to be honored by the third department. The third department just says anything. Anything. If the doctor accidentally says that they're separate, any garbage that the treating doctor gives that even remotely suggests that they're linked or in addition to, the doctor doesn't even have to explain the medicine. All they have to do is say that it's new. That's enough.
It's frustrating when you read these decisions too, especially I believe Germano. It's sort of just when I read it, I had to read it a couple times because they just sort of like, no, the board was wrong because the doctor mentioned that there was a distinction. There was really no analysis.
It was in an early case too. It was in an early medical report. It was like, oh, this is new.
This is different.
And just because he said that in passing, not even in response to questions about the specific issue, just in passing in a report, they said that's enough. Which is just, it's trash. It's bad lawyering on the part of the parties. It's bad judging on the part of the board, and it's bad appellate work on the part of the appellate division. I mean, they saw entirely separate and distinct. Like, what is that standard of proof? You have to be satisfied that they proved that, and they weren't. We got to jump ahead a few slides to Anderson because we only have 10 minutes left, and we really need to talk about Anderson because if you were going to describe this year in a nutshell, it's the year of psych claims.
Yes.
This case, Wright v. Elmer is really funny. The appellate division can't do math.
That's the only reason it's in there.
That's the only reason it's in there. Yeah, we put it in there because apparently, according to the appellate division, 40 plus 10 equals 45. And now I know I went to law school because I was bad at math and I couldn't be a doctor. So apparently I'm in good company.
Yeah.
That's good. Let's tell us about Anderson.
Yeah, so Anderson is probably one of the more significant cases from 2024 in that it sort of did two things. First and foremost, it kind of reimagined this the former idea of a similarly situated worker in a psych-only claim. Now, the general rule for the longest time was that if someone claimed solely psychological conditions, that they had to demonstrate that, or a defense to that would be that they were not exposed to stressors that were different from
or greater
than a similarly situated worker. Now, in this case, it's more, I use the term, and James has used it as well, reimagined to be that it needs to be something that's extraordinary or extraordinary. And in this case, it's sort of under the framework of COVID, in that they took the position, I believe this was Jeff Schotter, they took the position that basically these claims for psychological injuries due to the stress of the COVID pandemic and having to work in public should be considered on the same standard as though it was a COVID exposure claim, basically.
Yeah.
It's not exactly that, but it's similar. They said that there's a disparate, they argued, I believe the language was that there was a disparate burden of proof being placed on the claimant for these cases. Now, our response to that would be there always has been, and it was contemplated by the law that there should be a disparate burden of proof.
It's in the statute.
Yeah.
All you got to do is read the damn statute.
Exactly.
The problem with this case is it doesn't really read the statute. It talks about the Wolf case a lot. It talks about third department precedent that it's really enamored with,
right,
and just goes off the deep end with it.
And James and I had a pretty interesting discussion about this the other day because the next few cases are related to this, and there was a decision, Waddy, which came down ago, that sort of gets into this concept of cycle only and what is the standard. But there was a recent signed law by the governor, which sort of changed the law.
Well, it took the similarly situated can't stand as a basis to deny a claim anymore.
Right.
So they basically, although they left it in the statute, they added another section to the statute saying you can't use that to deny a claim anymore, which is somewhat consistent with what the court did in Anderson.
Right.
What the court did in Anderson was said, first you got to ask yourself whether this activity that the claimant is saying brought about the psych-only condition is something that is part of their ordinary job that you would expect, like as an ordinary part of existing in a workplace, or if it was something extraordinary.
Right.
And I said, listen, being potentially exposed to COVID during a time of a national emergency is extraordinary. And it's not, this is the only part of the analysis that I think has any academic merit, which is they say it is disingenuous to then say, because everybody else is exposed to the same extraordinary risk, that renders nothing compensable. And the problem,
true.
Except it's true, except the statute says we don't care about that.
Right.
We're not making a value judgment. We're asking, is it something that your coworkers were exposed to? This is basically a way to weed out. It's sort of an anti-eggshell plaintiff rule. It's a way to weed out people who are particularly susceptible or would be particularly responsive to the stress from those who aren't, and say, listen, if 5 people were exposed to the same thing and only one has the problem, that's your problem. That's not a comp claim. Now they said you should consider whether people were similarly situated in the context of determining whether the stressor or the activity or whatever it was that which they were exposed is extraordinary. Right. And that's what we get with the amended statute as well. Although there's a chapter amendment on it pending, and that's sort of interesting. But Brendan and I talked about this, both the Anderson case and the amended statute. At the moment, you may have counsel that have told you the sky's falling. We don't buy that. We think that what this is wordplay.
Mm-hmm.
This is nothing more than wordplay. In the past
doesn't change.
The defense doesn't change. It doesn't change the previously available defense of ordinary business decisions, right?
Mm-hmm.
It doesn't really change the fact that the only cases where it's going to really make a difference is if the activity or the event to which the employee is exposed is really something that is extraordinary or is beyond ordinary work events. I find a little bit of that problematic, though, because some of the judges that we appear in front of have never worked in a normal work environment, and perhaps some of the board members haven't either, and certainly the courts haven't. So how are we going to determine what is normal for that particular plaintiff's work and what is not? Well, we're going to describe what he and his coworkers do and what happens to them on a daily basis about their work, which is where we talk about what is the next case, Gorbia. Yeah, which is Gorbia and the Garrow decision that just came down, both of which affirm disallowances of site claims by saying, essentially, what the claimant says happened to them is something that is expected as part of their normal work. It doesn't disallow it saying that similarly situated people were exposed to it. They just say this is
extraordinary.
It wasn't extraordinary. It was part of their normal work. And the thing is, every claimant's standard for that is going to be different based on what their job is. So I actually don't see this changing the results. It's just going to change the words that we use.
It's also going to change, I think, the amount of times that we see these claims, because I think the claimant's bar is going to see this and say,
let's start.
Well, you basically have to establish it now. It can be read that way, even though that would be an incorrect reading in our opinion.
Every time they amend the statute, all they do is create expense and cost.
Right.
And this is going to be another one. We're going to spend the next 24 months at least getting panel decisions to tell us what this law means. And it's not even effective yet because the chapter amendments are still pending.
So just off of what James was talking about, he already kind of touched on Gorby. Just the facts of this claim so you can kind of visualize it. The claimant had PTSD pre-existing and claimed an exacerbation of it, basically related to, kind of like James mentioned earlier, a burnout type of situation. Claimed to be overworked and subject to constant intimidation and harassment. Now, that sort of sounds like fairly ordinary work, high stress work environment things, and the court saw it that way and deemed it not to be extraordinary and affirmed the disallowance.
Well, there was a little bit of BS in it.
There is a little bit of BS.
And there was a little bit of BS. So listen, we're done. I think we made it on time. What time is it? We actually, 1 minute. Does anybody have any questions? If you have a question, put it in the chat. Type it in the chat and we'll answer it for you. We can hang out for a couple more minutes if anyone wants to and answer any questions you may have. Type them in the chat and we'll answer it. Otherwise, thanks for joining us. If you would like a copy of the materials, and I'll tell you, it's over 80 pages long. It's in PDF format. It's indexed. It's beautiful. It's searchable. It has every decision that was published by the third department and a handful of decisions that were published by other courts that speak to the third department, so that you can have it as part of your library. Please email us at mail@madwcdefense.com. And we will get a link out to you so you can get a copy of those materials. Quite possibly the most useful thing, most useful document you might receive in the whole year. Even if it helps you a little bit with one case, it's worth it.
Absolutely.
So we have any questions? No questions. Excellent. Everyone is really educated and doesn't have any questions. They want to get back to work after the long lunch. Thank you so much again. I'm James Cousins.
I'm Brendan Shannon.
And thank you for watching. Have a great day.
See you next year.